live stream.
Mayor, if you use a microphone for the recording.
Okay, now it's here.
Ready to go? Good afternoon, everybody. Thank you for being here. This is not a formal meeting. It's actually a training session. So we appreciate you being here. I did call out that this would be mandatory so that, but I gave those that couldn't make it today an out that they can watch the live stream and talk with Max if they have any questions about anything. Transparency is one of our more important things, and we all use this opportunity to get on the same page with what Freedom of Information is, FOIA, as well as we're having a second session on ethics, and that'll define for us conflicts of interest and when we may need to maybe step out of the room and recuse, et cetera. So again, we'll all be on the same wavelength, but for those on the advisory committees. I know, Frank, you're on the Boardwalk and Beach Committee, but you're also on the new Mixed Use Task Force, so you're here as a member of the task force. Once we finalize, the commissioners finalize the process for advisory committees and rejuvenate them, then we'll invite them to partake of this educational series as well. We have our interim city solicitor here with us today, Max Walton. I would say he's an expert in freedom of information, and unfortunately, he has a lot of examples in his slides, I think, that show that we violated FOIA or something. So we use those as a good learning lesson. But Max Walton also teaches FOIA at Institute for Public Administration, so he's very well versed in this. I don't know, you can explain whether you want questions while we go or to hold out questions to the end, however you want to do it. So I'm going to turn it over to you.
We're going to start out questions anytime. But if I get too many questions, it's going to take too long. I'm going to hold them all to the end. So I get to choose, okay? For those I haven't met, thank you. Thank you, Mayor, for the introduction. And yes, I have been asked to teach about the most boring subject that I have to teach at the University of Delaware, which is FOIA. It's difficult. There's nothing fun about it, but we're going to do it, right? And so FOIA only has two things. It's open meetings and open records, right? And you would think that that would be pretty easy, that you would be able to come up with the answers for all that. And I will tell you, as I go through the cases, some of the answers that are given are not logical, not practical, and not simple. So we have to go through why is Freedom of Information Act? If you go to the Delaware Code, the General Assembly has said it's vital in a democratic society that public business be performed in an open and public manner. And the idea is that citizens should have the opportunity to observe the performance of public officials, and that citizens have easy access to public records. So over the course of my career, that's a lot of different things now, right? Now we have emails and text messages and all of those things we didn't have before, and there isn't a file anymore. One of the most litigated, or I'm going to say litigated, or one of the most complained of things is what is a public body? And it is an extremely broad definition. It includes any regulatory, administrative, advisory, appointive, or legislative body, any board, bureau, commission, department, agency, ad hoc committee. It's almost like any time anybody gets together, you could take it to be a committee. And there's all kinds of examples of that, right? So in Leipzig, there was a museum review committee that they appointed, right? And it's the mayor and the acting council secretary and a resident. Well, to me, that seems like a meeting, right? But because it was deemed an official committee of the town, that was held to be a public body where they had to have an agenda and then they had to keep minutes. Working groups subject to FOIA. Dover, the mayor, city manager, assistant city manager, and planning director, which seems like administrative officials to me, right? Not elected bodies, et cetera, but they were officially appointed to recommend disposition of the post office building. So that was deemed one. And there's another one. So in Christina School District, the board president and the board vice president got together to negotiate for the superintendent to kind of get the salary and do all of that stuff. And the AG's office held that there were those two board members were a committee because they were impliedly appointed to go ahead and negotiate with the person. This makes it very difficult for me to advise you all, and you'll come to me and you'll ask me, hey, is this in a body, right? Well, I'm just going to call it like it is. When the mayor or a council person and city manager have a discussion, that's not a committee, although they're talking about city business, right? The line is very gray from that point on to what is and is not a public body, right? And here's just one more. This was DENRAC, there was surf fishing program, right? And that the parks director said, hey, I want to get together this working group of people to sort of advise us on this surf fishing program. And so the Attorney General's office says it's a public body if it falls within the statutory definition, and every meeting falls under the statutory definition, right? And two, if the entity in question impliedly or is specifically charged by any other public official to make reports, recommendations, or investigations. So my advice, and by the way, I am temporarily the solicitor of Rehoboth, and I act as outside counsel for about 21 municipalities, 5 state agencies, and 2 counties, right? And so those agencies, whenever there's a question, I'm like, if you think you're going to get FOIA'd, yes, it's going to be a public body. So that's something to keep in mind. Every meeting is open to the public. So if there's any doubt, like you look at that meeting and you look at it, you say, if there's any doubt, let's make it public. And you have to hold it within the jurisdiction of Rehoboth Beach for Rehoboth stuff. Can't go to Lewis and hold your meeting, even if you notice it that way. And so I wanted to talk about other things, that other meetings, and I put this in here. It's serial quorum issues. Do you guys ever heard of that term? Functionally, it works like this, and it came out of a case, gosh, I'm getting old, 25 years ago, out of Milton. And what happened, I don't remember the specific disposition, but they wanted to buy a piece of land for some public utility purpose. And they set it up so 2 of the council people went with the realtor and viewed the property. And then 2 of the council people went and viewed it. So they never had a quorum of people all at the same time. And there was a FOIA violation because they all kind of went 2, 2, 2, 1, and then they had a meeting about it. And they said that was a FOIA violation because what they did was they worked to subvert the public meeting requirements under FOIA, and they called it a serial violation because everybody got the same information. They just didn't get it all at the same time, and they didn't get it from the public. Where that has manifested itself in the technology age is with respect to electronic mail. So I'm sure, and I've seen it, in Rehoboth, I get a blast. We're going to have a council meeting on this day, and this is going to be it, right? This is what's going to be on the agenda, or this is going to be the discussion. There's nothing wrong with informational stuff going out by email, but when you turn around and you start applying, reply to all, and you say, hey, I don't want item 3 on the agenda, or it continues on, well, I want item 3 on the agenda because blank, 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 blank. Well, what are you doing? You're discussing public business outside the public, not in a public meeting. So you can't really reply all to all of those, and you can't kind of come up with a workaround. Everybody's smarter than FOIA, right? Because it's a pain, and they want to sort of work around that. I had a situation where I thought it was a bad move, but it happened in another municipality that I represent. I can't remember if it was the council or the planning commission wanted to have a meeting at a site, and so they wanted to go out and view the site at the developer's or owner's request. So we had to have a public meeting that went, and an agenda that said, we're all going to meet here. And that's the way we had to do it, but everybody wanted to subvert that requirement, right? There's a new provision within, and you guys follow it as far as I can tell, at least with commissioners meeting, the agenda for every committee, everybody has to have a section for public comment. So that can be at the end, right? You have to have a meaningful opportunity for the public to engage, right? And it's reasonable time, place, and manner restrictions. Why is that important? Most of the time, you guys are pretty liberal with your public comment. From what I've seen, people stand up and say whatever they want to say. I will say that I once had a hearing in Newark, a Board of Adjustment hearing, and there were, I think, 1,100 people that attended. I had to be escorted in by the police, and it was kind of scary, right? It was before this law. Can you imagine if we had to allow 1,100 angry people to talk? So there's time, place, and manner. So what we would have done is had to sign up ahead of time, and we would have allotted an hour, 2 hours, or 3 hours for public comment and cut it off because you could have never gotten through 1,100 people, right? You have to give notice of every meeting at least 7 days in advance, right? And a meeting with 7 days in advance is called, under FOIA, that's a regularly scheduled meeting. Might be a special meeting for you because it's on a different date, but it's a regularly scheduled meeting. My view is every meeting ought to have 7 days notice. With the only exception, let's assume, just for a moment, that there is a hurricane bearing down on the city of Rehoboth Beach, right? And we have to allocate or do something ahead of time. That's about the only time I would say you could have a meeting on less than 7 days notice. It has to be something, right? What is notice? It's where you post it at City Hall. And I don't think you guys do virtual meetings anymore. You did some during COVID. You have to provide the contact information right in the agenda, right? You can amend the agenda. This is where everybody confuses what I'm going to say about amending the agenda. So if you're going to amend the agenda, you have to provide a reason or an explanation why 7 days notice couldn't be given. So there's a couple of things. In Rehoboth, we embed things in the agenda, like letters and all of that, those kind of things. Perfectly fine. Ann puts it in, embeds it in the agenda. She puts a little reason why we're embedding stuff in the agenda. That's not an issue. But but besides that, sort of, I'm going to call it a ministerial or informational role, where you have less than 7 days. Let's say I'm representing the city in a case, and we have a meeting today, this Friday. But the Tuesday before, I got a decision in a case that I needed to figure out whether I needed to file a motion for re-argument in that case. I only have 5 days to file a motion for re-argument. So I could have amended the agenda for today to have an executive session about that thing that came up with less than 7 days notice. So it can be done, but it's very rare. The agendas are defined as a general statement of the major issues to be discussed at the meetings. And a lot of times, most agenda things that I see that are changed are deletions, not additions. You can delete in less than 7 days, much easier than you can add. If you're going to add something, you have to give at least 6 hours notice. And I always have my little hypothetical in here because it happens all the time. Council members, nope, never happened in Rehoboth, but council members in other places say, this is really important. We have to add this on less than 7 days notice. And I say no, because they could have given 7 days notice. Simply because they didn't get their request in or something else doesn't mean it's considered at that meeting. So there always needs to be required minutes, right? And what do the minutes need to say? They need to have a record of the members present, right? And each vote to be taken. And minutes of executive session have to be kept as well. And they are not public documents, are not considered public records so long as the public disclosure would defeat the lawful purpose of the executive session. So let me give you an example of when that happens. Let's assume, just for a minute, that the city of Rehoboth Beach is looking to purchase land for some reason, like a public utility use. We'll use that one again. And they're looking at 3 different parcels. And they have executive sessions on which ones they should buy. Their competitive advantage, if everybody knows they're going to buy this parcel, is diminished, so they can talk about acquisition in executive session. However, once they buy and purchase the property, the reason for the executive session is no longer there. So even though they were confidential during the time period when they were negotiating, once they purchased the property, then those executive session minutes are no longer public minutes. There's a difference. If I give legal advice or a legal memo, right, that never goes away unless the council votes. So attorney stuff, you're never going to get under this exception, but acquisition stuff, you might. I want to talk about executive sessions because they're closely scrutinized, and I'll just give you the big ones, right? the individual citizen's qualifications to hold a job and to pursue training. That's for the one you use when you're hiring somebody. City manager, city administrator, police chief, et cetera, et cetera. You can go in and you can talk about them. It does not apply to people like me, who's an outside contractor, solicitor. So solicitor discussions are in public. Now, it seems odd to discuss because I got attorney-client privilege once I'm hired, but until I'm hired, I don't have any attorney-client privilege. So strategy sessions with an attorney at law regarding collective bargaining or pending or threatened litigation. Guess what? Every darn thing we do in a city is potential litigation, right? Because it only costs somebody $250 to go down to the courthouse and file a complaint. Depending on the court, it's only $100 in some of them. So you can't go that broad, right? Every Board of Adjustment has the potential, decision has the potential to be challenged. That could be pending litigation. And the reason is it's likely, so that there's a test, and the litigation has to be likely foreseeable. So if sometimes I got a letter from somebody that says, I'm gonna sue you, pretty easy to go into executive session. But sometimes you don't have that, right? So one time, long time ago, I represented Newcastle County, and we had over 20 cases brought by the same guy. And he was a big developer in Newcastle County. I had 20 cases. Well, every time that guy said something, there was potential litigation because you knew he was going to sue us. So that would be okay. That's what they're talking about, the pre-existing litigation, right? And really to determine if it's pending or threatened litigation, it has to be a realistic or tangible threat. Somebody comes up to that microphone during an executive session or during a meeting and says, I'm going to sue you about blank, probably good enough. If it's a person who says it every week and doesn't do it, probably not good enough. So I hate the test because it's not concrete and it's based upon a lot of factors, but ultimately you have to go through it. The DELDOT had that same situation in this particular case. And so there's a guy who likes to sue DELDOT and other municipalities, and he went to DELDOT and had a FOIA request after DELDOT refused to accept certain subdivision streets. And because this attorney sued DELDOT quite a bit, they said, nope, we're not giving you that information. Well, he filed and said that was a FOIA violation. So they said, two-pronged test, litigation must be reasonably foreseeable, and there must be a clear nexus between the documents requested and the subject matter of the litigation. To me, guy sues you all the time. You have a dispute. It seems to me like pending litigation. But the AG's office did not see it that way. So what else is considered a executive session permissible? One is where it's the content of the documents are excluded from the definition of public record. And we'll get to what's a public record in a minute. But what is that? Attorney-client privilege documents, like a memo I write to counsel or to my client, that's excluded. If we had things, for example, like infrastructure, things that are protected, police things that are protected, those fall under this exception. You can have an employee hearing in personnel, right, in disciplinary cases. And when you want to discuss a particular employee, personnel matters where the names, competencies, and individual of employees are discussed, unless the employee requests that such a meeting be open. So that means if I'm the employee, I have the right to request it to be open. And I always thought, I was like, well, if I have the right to be requested that be open, I have the right to be told about it. And that is not what the law is. Remember I told you FOIA is not logical? I don't have to tell that employee under the current iteration of the FOIA decision by the Attorney General. I don't have to tell the employee I'm having an executive session about them. If they find out, they can request that it be public, but I'm not required to tell them. So minutes of all executive sessions must be taken. You have to have it on the agenda, and you have to be specific about the statutory sort of thing that you have. So a lot of people, the gray area is if you just put on there personnel matters, right? Sometimes that's okay, and sometimes it's not. It depends on what the matter is. So those who have been in executive session with me know that I always say it exactly the same. I start every executive session exactly the same way. You can't take any votes in executive session. All votes must be taken in public. The executive session topics can't stray from the issues on the agenda. Never happened here, but I go in places and we're in an executive session about a litigation, and then the council veers left and they start talking about the employee that they don't like the job they're doing. No, that can't be done. That's not proper because you're only supposed to talk about the agenda and you're prohibited from having a straw poll. You can't make decisions in executive session, like you can't come to a consensus. I was at an executive session, can't even remember what jurisdiction it was, not too long ago, where I had a discussion about the legal topic, and the first person, I'll say council person, says, yes, this is what I think. The second one says, well, this is how I would vote. And then the third one came up, and I was like, stop, because what are you doing? You're trying to figure out where everybody is so you can reach a consensus, and that you cannot do. So let's talk about what public records are. Public records is everything. It's everything received, produced, composed, drafted, in any way relating to public business. So that can be a model of the Brandywine Town Center, which is a public record. It can be emails, text messages, whatever it is, right? So as a public official, everything you do, you have to make an assumption that it's going to end up on the wrong website, or a blog, or a paper, or whatever. You guys have a little more better press here in Sussex County than we do in Newcastle County because we have followers here. But you got to assume that everything is, because guess what? You can do it. And by the way, I do a ton of litigation. It's my real job. And we have electronic discovery requirements that we have to do for federal court cases. And what we do is we flash your hard drive, take all of the stuff out, and then we have to run searches and sort of work through that. First thing I do once I get my first round searches, I have a list of cuss words, and I run that search. Do you know why I run that search for cuss words first? Because guess what's going to be the document that killed me, the one that you were cussing at the individual. Don't do it. Anyway, that's it. And that goes whether or not you're on a board or a commission or whatever. That is just something to do. And you should have a designated email or contact for your public business that's different than your private business. Because I'm going to have to come in, I'm going to have to get the FOIA stuff. And don't think you're going to get away with it, because people have tried. They have for example, I'm going to call it in this case, City of Newark email address, right? Well, to get around FOIA, they're smarter. Everybody tries to outsmart FOIA, right? And then they go and they're like, I'm going to use my Gmail to send this public business, and then nobody's going to know about it. Well, let me tell you something. Once discovery comes, and once electronic discovery comes in that lawsuit, it's all going to come out. So, but let's talk about what records aren't public: personnel and medical files, trade secret or commercial or financial information that's confidential. So that would come up if you had some sort of double secret redevelopment project and you're trying to lure somebody in. I've seen it done that way. Law enforcement, investigatory files, criminal records, intelligence files for law enforcement. There's a lot of law enforcement exemptions. Any records specifically exempted by disclosure by statute or common law. So there's plenty of protections for different things within the state government where different categories of things. The one I can think of right now relates to unclaimed property, and that's common law, so you could exempt those. Common law things would be things like attorney-client privilege documents. They would be exempted from the definition of public documents. A bona fide contributor, I hope you guys have a lot of them. You keep those quiet, and I hope they help the public fisc. Labor negotiations, any records pertaining to pending or potential litigation. Let me give you an example. If you have a FOIA request, you have a suit against the city, and then you submit a FOIA request, the city denies that FOIA request because you have another way to get it through your legal process. So people, again, try to outsmart FOIA, and they would go and they would get their neighbor down the street to FOIA exactly the same information that was pertinent to their lawsuit. And they would say, well, I'm not involved in that lawsuit. And very recently, the AG's office, and rightly, said, look, if it's pertaining to a lawsuit, the requester, the identity of requester doesn't matter, because ultimately you can't just subvert the rule by getting someone else to do it for you. Minutes of executive sessions are not public records. a permit to carry concealed deadly weapon, not a public record. Library card, library information. Once you check out a library, you're good, not a public record. So this is my favorite one. Emails received or sent by members of the General Assembly or their staff, right? So read it closely. Emails sent by members of the General Assembly or their staff, that's one. And then number 19 is communications between a member of the General Assembly and the member's constituent. So if I have a letter exchange with a constituent, it's got to be my constituent. That's protected. But otherwise, if it's not a constituent, let's say it's the senator from Newark sending it to Mayor Mills, that's not one. Sending a letter to Mayor Mills, that's not a protected, or that's deemed to be a public record. And a few years ago, I represented the office of the governor. And the thing was, they said, well, the email has to be sent to your constituent. That's what the AG's office held. And my argument was, no, that's not what the statute says. Let's look at the statute. It says emails received or sent by members of the General Assembly or staff. And the other side argued, and I think made a good argument. They said, well, what if you're friends with somebody in the General Assembly or their staff? You copy them on the email. Does that automatically make it so that that email is not subject to disclosure under FOIA? It's not a public document. And the court, and I had to think long and hard about how to answer that. I'm like, but that's what the statute said. And ultimately, the court held that the AG's office got it wrong, and so long as there are emails from the General Assembly or their staff, then that is not a public record. Interestingly, they never amended the statute on that in that regard. So a few questions, right? Can public comment be limited? This is my FOIA quiz. Yes, you can limit it to a reasonable time, place, and manner. If somebody comes into the city and gives the city a list of questions, are they required to respond under FOIA? The answer to that is no. FOIA is about producing that which we have. You do not have to create documents under FOIA. So what if you have a confidentiality clause in a settlement agreement? So a lot of insurance companies heretofore had put these confidentiality clauses in there because they didn't want to know what anybody else got paid. And even if the city doesn't touch it, because the city paid the money to get the policy to do the settlement, the public is entitled to know what that settlement was under FOIA. Another question, if you're going to hire a high-level official, let's say a solicitor or something like that, or a city manager or whatever, there's a FOIA decision that says the council wanted to go in and get advice on interview questions that they could and could not ask. And that had to be done in public, and that found a FOIA violation. One of my favorite ones is I was in a meeting, and I was actually at this particular meeting, and it was very high tension. And one of the opponents of the then mayor of this municipality said some things and to one of the other council meetings, and the public comment came up, and the lady said, "You treated him like the pubescent son found with a porn magazine." And the mayor said, "Get out." Police, got the police, yanked him out. Now, I didn't think this was going to come out that way, but it was a FOIA violation. He took away my right to attend the public meeting, and they said that was okay. They didn't do that. I haven't seen any evidence of that sort of vitriol here yet. So you're allowed to ask for additional time. You can't just say, I need additional time for anything if you have a FOIA request. So you can say, look, we need additional time because it's an overwhelming amount of documents we need, attorney review, something like that, but you can't just extend forever. And you can deny FOIA requests from out-of-state requesters. So if you get somebody from Texas or whatever, and you'll see those, especially in, folks, especially if you have an RFP or a contract award for like IT or that kind of thing, you'll see a lot of those FOIA requests. So I thought I'd go through some of the Rehoboth ones, just so everybody knew what the Rehoboth ones were. And so there was an allegation that the Board of Adjustment committed a violation because there was a 3 variances on the agenda, and then there was a 4th variance relating to the Baltimore Avenue property. There was some question about that. And what was held is the purpose of FOIA is not to provide a series of hyper-technical requirements that serve as snares for public officials and frustrate their ability to do the public's business without adding meaningfully to the citizens' right to monitor that public business. And they said because the variance sought for the off-street parking requirements was noticed, that they didn't have to have a specific reference to the Baltimore Avenue property. So the Board of Adjustment agenda was okay. We had this one that there was a FOIA complaint that the city failed to follow the open meeting requirements when hiring the new city manager. And at the end of the day, the Attorney General's office said that discussion of an individual citizen's qualifications to hold a job, this exception does not allow private discussion of employment agreement and compensation. I personally think we have to follow this. I personally think that once that gets litigated, I don't think that's going to hold up, but that's what the law is right now. It's difficult to divorce discussions over one's ability to do a job and compensation. There was this violated a meeting by holding a vote about selecting the new city solicitor without sufficient public notice. And it was the city's burden, and in all FOIA, it's the city's burden to justify that they met it, and if they couldn't meet it, that's what happened regarding the executive session. Again, it would be my advice whenever you're dealing with a contractor to hold that in public, even though it's very uncomfortable for the lawyer who you're talking about. That's what the law requires. This one was a nomination of an individual to fill a 2-year term, and the city amended the agenda to include the name of the nominee less than 7 days in advance, and there wasn't a footnote saying the reason for the delay. So I think if the city would have added a footnote and said the reason for the delay is the person didn't ask us to, whatever. There's some reason given. I don't think this would have been a FOIA violation, but these are the decisions. And then the last one, where it was alleged that again, this is the beginning of the iteration of everything is a public body, that where there was an attendees, a public meeting that occurred, where the attendees were the city manager, clear space, city departments, and all of that. They said there was no FOIA violation, at least in this case, because the people weren't appointed or established by the city to do it. And that used to be the test. If it was appointed by a council, then that's a committee. If it wasn't appointed by a council, then that's not a committee. That is going off the rails. That is no longer the law. I gave that advice for years. And you have to look at it each on a case-by-case basis. And there's last one there, and then I'll get off of picking on Rehoboth. The Personnel Committee was deemed to be a public body. So let's talk about how we produce documents. You have to make them available during normal business hours. You guys have it. You have request forms on your website. You have to make them in writing. You can actually discuss with people, I want blank. And then I usually just call them up and I say, you want blank, but we don't have blank. Do you want this other thing that we can help you, right? Try to help people out, right? So you can charge for fees, but for anything that takes over an hour, and you can bill at a quarter of an hour increments at the lowest salary rate to do that. I just thought I'd give you some recent decisions, phone calls and emails resulting in a decision in Georgetown, violated FOIA. They said, actually, I think this is the one where the city manager said to the paper, she's like, well, I talked to these people and had emails with these people and then made the decision. Well, that's a serial quorum. They talked to everybody and they did it, right? Sussex County, there's no requirement to post an agenda on the website. You may have a code requirement here in Rehoboth, and that may be what you do with every agenda. And I can certify it for years. That's been the practice. It's not a requirement. And when we're talking about other things, you're not required to state the names of the personnel to be discussed, but personnel action items is insufficient to alert the public of a vote on a superintendent. So you need to be much more specific than that. These are just failing to notice committees, Advancement and Finance Committee. And the last one is Delmar. What happened was they went in, they had a public meeting, and the presiding person, the school board chair, he told everybody he was in the audience, we're going to have an executive session so you guys can all go home. So everybody went home, and then they came out and they had to keep vote. And so, in other words, he should have said, we may take action when we come out of executive session. I'm going to pick on my good friends at Newark too, because I've spent a lot of time there, and that's where I'm from. And that if you go in, there's a sliding door in Newark, and so we would hold executive sessions at 5:30 or 6 o'clock, and we would go into the chambers and start the meeting and then go out. So what we didn't realize is that the door locked. So we were all in having a public meeting, and people were trying to come in to at least watch the beginning of the meeting. And we were violating it because we didn't know that the door actually locked by itself. So that happens. So even getting together to sign a check for the Historical Society was a group, and it needed to be done at a meeting. So under FOIA, the Attorney General's office, it's a very informal process to make a complaint. And the statute of limitations is 60 days for public records denial. And if you allege a public meetings, it's 6 months. The burden's on the city, and usually, and I hope I don't have to respond to any FOIA issues, well, in my limited time with Rehoboth, but you have to do it by affidavit, and you got to get everybody together. If there's a FOIA suit, the successful person gets attorney's fees, and you may be required to forfeit compensation in certain instances. And it says, the statute says the Attorney General's office may hear prospective violations. To my knowledge, they have never decided a prospective violation, so they don't do that. So let's go on to a little bit of ethics. And you guys are subject to the Public Integrity Commission, and ultimately, the Public Integrity Commission's job is to set standards for state personnel, and that applies to you all, state personnel, without unduly subscribing their activities. You guys could adopt your own code of conduct if you chose. I forget how many jurisdictions have done that. I'd say less than a quarter, but it has to at least meet the level of the same level of standards and requirements as the state code. So I'm going to go over the state code today. This is what they do for the PIC members. And what they do, they issue advisory opinions, they investigate, they subpoena witnesses, they do all kinds of stuff. If you've ever been a PIC proceeding, it's not a fun thing. It's kind of like court. I have been in one, and it was not fun. It wasn't against me. It was against one of my clients, and it was not fun. You cannot participate in the review or disposition of a matter where you have a personal or private interest. So a personal or private interest is an interest which would tend to impair a person's impartial judgment in the performance of their duties. Do you know why I hate that? Because that level is different from every human being. And so all we have to do is we look, right? I mean, what might appear to impair my judgment, right, might not impair yours, right? You can keep it up ahead. So this is how it's defined. If the employee or officer or close relative will receive a financial benefit or suffer a detriment to a greater extent than what accrued to the members of the same class, or if there's a financial interest in a private enterprise. So that's kind of what you look at. Financial interests are always disqualifying. And I'm going to get to you some of the difficult ethical ones that we have to deal with, but when there's something you delegate that responsibility, and I'll pick on Taylor because he's a city manager and he's here, right? If in this situation, if you had to delegate, you might have to delegate to Evan, right? Because you had to do something where you had a financial interest. And then in that, you have to provide written notice to the Public Integrity Commission if you couldn't do so. So I can't assist people. Like if there was a developer, like certainly I couldn't assist them in sort of their application. I can answer questions for them on behalf of the city, but I can't help them. I can't assist a private enterprise. This is how you get something through the city. But you can do it as a course of your job. So the statute says you have an interest if you have a 10% or greater ownership interest in the entity while it says 10%, that's not the way the PIC interpreted it. They use much more of an appearance of impropriety standard. So even though they have some exceptions here, they're never applied. And for a period of 2 years after employment, we can't be involved in something that you gave an opinion about, investigated if you're police, or was responsible for while you were in the employ. One of the things I would say, one of the most violated portions of the public integrity statute is confidential information. And it's a violation of state law when I go in to an executive session with whoever my client is, I give you my view on something, that's confidential information, and then somebody turns around and gives it to the press. That's a violation of state law. That's a violation of a lot of things. So, and it's also a violation of state law to not disclose financial interest. You should disclose them. Sometimes they're very remote, and we'll get to them. We'll get to a couple of examples. So at the end of the day, the Public Integrity Commission says, don't act in a way that makes you appear that you're violating the public trust. And that's the appearance of impropriety standard. And I will tell you, I've been doing this for 25 years, and every time it's a fact and circumstances test. And you may have a different view of what's an appearance of impropriety. So I think my next slide's right. Is it an appearance of impropriety when you're judging something when you worked with a person 15 years ago? Is it an appearance of impropriety when you donated to a campaign? What happens if you're divorced from the person, right? Or is it an appearance of impropriety that you as a member of council, right, you're asked and you have a rental property, and then you're asked to vote on a proposal to raise a rental permit fee? Well, if you weren't allowed to sit in on the rental permit fee because you owned rental property, could you then would it be an appearance of impropriety to financially to vote to raise taxes? See how far this is? It's a continuum. So it's just tough, right? How about voting on the budget when your daughter-in-law or your son-in-law is on the police force? Is that an appearance of impropriety, right? What if my wife's law firm, my wife's not a lawyer, but what if my law firm is going to benefit from your vote, right? So there's all these things, and these are real cases that I've sort of put forth, and there's different things, but in most of these cases, most of the things that I just gave, there was an appearance of impropriety found, except for the vote on a tax increase. I personally cannot distinguish voting on a rental permit fee for a rental unit and voting on a raising taxes, but I don't get that. So these are non-ones. You shouldn't, can you appear if you regularly, can you vote on something? And well, Commissioner Gossett gives out Christmas presents to this person for every year, and then they come before us, right? Where do you draw that line? There's a case that a member of the Board of Adjustment said, I don't believe we should ever grant this type of variance. Well, that's disqualifying because they're there to grant the variance. So you've prejudged that application. Making public statements about a project will do it. And one of the worst parts of my job is I have people who come up and they are on council, they run as opposed to some development project. And I'm like, I'm sorry, you can't vote on that development project because you prejudged it. I don't like that law, but that's what the law is. So, and if you don't recuse, it's improper. Not only do you have the penalties that are within the state, but if you do it as a matter of a public body, your vote, one bad vote taints everybody. So if you had to recuse and you didn't, even though, let's take the commissioners in this case, 7 commissioners, one person should have recused and didn't, the entire vote of the council is tainted under Delaware law. Shouldn't ever accept gifts, right? And I laugh because, there's a restaurant right across the street from my office, and I don't go there often, but when I do go there, I always see one of my clients. I'm like, hey, let me buy you a beer. And they're like, no, I took your seminar. I can't take a beer from you. That would be a gift. And I'm like, no, I don't want to take it that far, right? So it's got to result in preferential treatment, results in a governmental decision, but it's got to adversely affect the confidence of the public, right? So basically, file disclosure statements if you need to come up, seek an advisory opinion if it's close, go to whoever your solicitor is or is going to be, right? Don't give away stuff that's confidential information, because it's not only you're violating the law, you're hurting the city. Because I had a case, and I was very young in my career. They had an executive session, and this is how old it was. The mayor then faxed it to the News Journal, and that stuff came out. And there was a $42 million judgment that started the train rolling against the municipality that it happened to. So I know nobody ever uses a fax anymore except for doctors, but still in all, that was kind of intentional. So at the end of the day, well, I'll go through this one example, and then I'll take questions. This guy from town council wanted this historical artifact. I don't know what it was. And he attempted to get it appraised. He wanted to buy it from the town, and the town was like, well, we'll give it to you. And then so they went to the PIC to get an opinion. They say, so asking for the gift, they said, was an impairment of judgment. Giving it to the person rather than selling it through bidding would be preferential treatment. And giving that property away would be an appearance of impropriety. So there are times, just real quick, you can have a waiver of sort of certain standards. A lot of people in post-state employment do this. I don't see it very much in the cities. There's an opinion procedure. You never want to go through a complaint at the Public Integrity Commission or get a complaint against you. Many of them are dismissed as frivolous, but if you go forward, it's a trial, notice opportunity to be heard, subpoenas, witnesses, and all these stuff. And the commission may censor, may remove certain people. They can sanction or request removal from office. So these items, gifts, misuse of public office, and private disclosure, those result in administrative sanctions. Criminal sanctions, if you participate in matters of a personal private interest that would tend to impair the judgment. You represent people and private enterprises before your own agency. You have contracts with the state improperly, or you violate that 2-year window. So what can the PIC do? A contract. So let's say a contract was procured, let's say for garbage services or whatever it was, or IT services. If that was done improperly, that can be rendered void, and that fills out all of my statements. I didn't know if I went really fast because Commissioner Good said, I hope this doesn't take too long, and I was like, I want to go home, and so at the end of the day, I tried to go really fast, but I thought I'd get interrupted at least once, but I didn't. And the poor guy over there who's got the television camera has got to be bored to death listening to this. So anyway, yes, Mayor.
I've attended a lot of these, and there's probably one of the biggest questions asked on an annual basis by members of the committees, et cetera. It has to do with personal emails. Now, I know you hit on it quickly, but just a reminder that as a commissioner, I have a city-issued email, and somebody can FOIA, and all my city business is done on that. Now, I still get some constituents emailing my personal email because they knew me 30 years ago.
That email is not protected.
Correct. And so what I do is I forward my personal email to my city email so that I have a finite record. But what I wanted to do is stress that for everybody else that doesn't have a city email address and only uses their personal, it is FOIAble. So watch what you say.
Right, watch what you say. And I would suggest, it's so easy to get a Gmail or whatever account. I would get, just like if you're on a commission, for example, right? You're not going to have that much city business. You might have some. Just open up a dummy email. Just use that for your public business. Because here's the fact. Under FOIA, people try to hide. Everybody tries to defeat FOIA. Everybody thinks they're smarter than FOIA. And they go out and they get a private email and they're doing all this public business. Well, somebody's going to find out, right? And if we get in a federal court litigation or a chancery court litigation, I got to go flash all that stuff. It's going to come out. I'm going to find out what your email was and all of those things. So if you have it dedicated and say, this is where I do all of my public business from, then it lessens, because there's some stuff, not mine, you can flash mine anytime. You can take my computer, I don't care, you can look at anything on it, but there's stuff on there that I wouldn't want other people to see, like financial records or social security numbers or stuff like that. Well, if I gotta go flash your computer, that goes into my possession as the lawyer for the city. Now, I have a duty to not make sure that that doesn't go out from there, but still, it's other people looking at your stuff. So if you just kept it to that one place, it makes it so much easier. That one email, just get a dummy email and use that for your city business. Are there any, yes?
I have a question. I'm on the Board of Adjustment. I understand explicitly that we don't talk about cases except with our attorney before they're listed, before the hearing. But what I would want is a little clarification on what information, since everything is a matter of public record. It's filmed, we have minutes, we have all kinds of stuff. But after the case is over, after it's been decided, and variance has been given or not given, how much or how little, what are my constraints? As a neighbor, as a person who's lived in Rehoboth for 30 years.
So,
People say, hey, I know you're on Board of Adjustment. If they ask me before, I say, don't talk, I can't talk, but it'll be broadcast and so forth. But then afterwards, well, what did you think? And, I usually just kind of tiptoe around it.
yeah, I think you're right to tiptoe around it.
I do.
And
I
so,
wanted to-
so a member of the Board of Adjustment has different immunity than, say, a commissioner or a member of the city, because you have judicial immunity. You act as a judge. So you need to act as a judge does. So if somebody said, how did I present? Or maybe this is something you can do better, even afterwards, you probably talk about that. But if you talk about the intricacies, it's not really proper to talk about the intricacies of the case after it's over. Well, you didn't do this because, your decision's supposed to be on the record in that decision.
But even though all of the testimony, be it from the city or the applicant or whatever, or what we said in our discussions, is all matter of public record, we still, even though we were part of that, we still.
You have to show some discretion on how much you discuss what you discuss there, because what if it's appealed, right? If that decision is appealed, that's where you get into trouble. That's why I tell people not to do it. I make a controversial decision, and I go out and I talk to the press about it. Well, guess what? Whoever's appealing is going to take your statement that was in the press and not what was on the record against you. So that's the reason. Think of yourself just like a judge. How would a judge act? Like, I go up to judges, how did I do in that argument? Well, you fidgeted too much, Max, right? You moved around, as you could tell, I moved around a lot. You fidgeted too much. And I was like, okay, that's good feedback, right? But they're never going to come up and say, I didn't like your argument because of X, Y, and Z. See the difference?
Well, right, and that's really the perspective that I've had, but I just didn't know if there was a good linear just line that we could look at and say,
Yeah.
here's what's okay and here's probably what's not.
I would say really discussions of the substance of the appeal, getting down into the substance or the X, Y, and Z, or getting into a debate about that. I think you ought to stay away from that. But as a general, maybe you could do this next time. That's okay. But I don't have a line for you. All this stuff is very fuzzy. Appearance of impropriety and
It's mostly gray area.
yeah.
Another question that I had that was brought up by your PowerPoint. You said we shouldn't be giving advice. And when you say that, would you define what you mean by advice?
Trying to.
I know we don't necessarily in the hearing, but people. I've lived here a long time, and people will say, "Well, should I have done such and such?"
I think that's okay. I think in that post. So in other words, if I'm giving advice, right? When I was talking about giving advice, I was trying to remember what part of that I was talking about, right? So when I was speaking about that is, let's say I want to get a liquor license, is my example, right? And Commissioner Gossett's out there talking to that person in advance on how to get a liquor license, but then it's got to have a permit of compliance. It's got to come before the city. you know, that's sort of giving advice to that applicant on how they can kind of get through the process. If it's post hoc afterwards and it's something they might be able to do better the next time, I don't have as much problem with it. Does that make sense? But you shouldn't they got to make their case and you shouldn't make their case for them.
Right. Okay, well, it sounds like I've had the right perspective, but I need to keep it up.
Sounds like you're spot on. That's right. So,
Thank you.
any other questions? So I'm going to go to this nice lady and I'll come to you.
Oddball question. I'm on the Parks and Shade Tree Commission, and we have 5 members. We had a case a couple of months ago, and one of the members was absent for that case. What is the quorum now for, it's still 3 people? Okay, so now one of the members who was part of the 4 has resigned. So is it still 3 people?
Still 3. A quorum is a majority of the body, right? So if it's 5 people, it's 3. If it's 7 people is in the body and it's 4, that's the way it works.
Body present or as appointed.
In order to meet, to get that quorum, if it's 7 people, like 7 commissioners, you have to have 4 to act. If you have 5 Parks and Shade Tree commissioners, you have to have 3 to have your quorum. And there's different, and not to complicate the subject, but there's sometimes different rules whether or not it's a majority of the members present or whether or not it's a majority of the members of the body. Depends on how it's written. So for example, talking about the Board of Adjustment, I find it very odd. Kent County Board of Adjustment, it's a majority of the members. So even if they only have 5 members there, you got to get all 5 or the thing passes or the thing is defeated. So one person could defeat, it could be 4-1 and still be defeated.
Just, could you give us any perspective at all about how the AG's office works with the FOIA? Is that just one attorney that handles it, or multiples, or regional?
There's I don't know exactly who's doing it right at the moment. For a number of years, it was primarily Dory Cole, who was the one who was doing a lot of FOIA decisions. It's kind of a terrible job. I like Dory a lot. She's an old friend of mine, but she was doing the majority of them. I think that, and you'll notice at the bottom of many of them, it'll be reviewed by the state solicitor, who is Patty Davis. So it depends. Decisions do depend on who's the FOIA DAG a little bit, just like any Superior Court judge. I don't mean that as it's going after Dory in any way, but yeah, it does depend. And but how they assign those, you know, which DAG you get, that kind of thing, I don't know. For state agencies, there's a prescribed method that it's got to go a little bit differently than with municipalities, but I don't know the current workings of the AG's office.
There is potentially consistency in the way decisions are rendered from the same person or body?
Yes. Yes. I mean, look, when I come here to do this presentation, which I do 4 or 5 times a year at different places, what do? I go pull up every AG's decision from the last time I did it, and I read them all to make sure that and there are sometimes inconsistencies or overrulings, but just like court cases, they try, and we're all human, but they try to make them consistent with their prior precedent. And again, I don't agree with a lot of these decisions that they made, but that's what the precedent is, so that's what we have to follow. Yes, sir.
Question about the non-public records for your state legislature.
Mm-hmm.
Did they pass that law saying that like, how did that law get in?
You mean on the public records? Yeah, the public records, it's all state law. So well, I think your better question is, they exempted themselves from FOIA.
Right.
Yeah, so they got to pass the, excuse me, something's going on with my phone here, sorry. They passed the law and said, you guys have to follow it, but we don't.
Okay. So like the city couldn't say, well, we're exempt too, because they're not a legislative body?
Yeah, because the state, because the General Assembly, so if you go to the hierarchy, right, federal law, you know, federal constitution, federal law, and then state law, or charters of state law, and then municipal ordinance. Because we're a municipality, we got to follow that state law, and that's just the way it is. And then the General Assembly is like, ooh, that kind of stinks. We don't want to have to do that too. So it's a fact. I mean,
Is Congress the same way?
There are, I don't know the answer to your question. I'm sorry. I don't do, I do federal court, but I don't go much farther than there. Any other questions? Sir?
Quick question. You know, we're a small community and, you know, everybody has an opinion on everything here.
I've noticed that.
But, I've also seen a number of people who are involved, and so as a consequence, sometimes they're serving on one of the boards or commissions, and then at some later time, they're serving on a different board or commission. Or we've had people who have served on, say, the planning commission, became a commissioner.
Sure.
Back at the planning commission. So in terms of recusal, if they made a comment while they were a commissioner, do they have to recuse themselves?
So I had to confront this recently, so I don't want to talk too much about it because I actually rendered advice on it. But my view is you got to look at that on a case-by-case basis. All of these things, you got to look at it. You got to look at this, what was said, the severity of it, put it in line with everything else through it is. My default is to allow folks to participate because you got elected to do something, you participate. That's my default. But then you got to go back to the rules and you got to look at them. Merely because you were on the Board of Adjustment at some point in time, and it's a Board of Adjustment thing that's getting decided, that's probably not enough. But if while you were on the Board of Adjustment, you were hectoring and sarcastic to this applicant who now you're going to hear about, probably not. So I use hectoring and sarcastic because my very first case for the city of Rehoboth Beach was in 2004. And the judge actually wrote, even though the commissioner was hectoring and sarcastic to the applicant, it was okay. And I always remember that. Yes, Commissioner.
I'm glad that Rick Perry brought that up, and I'm a little surprised to hear you say that your default is to allow participation. I think we have an endemic problem here with this recusal standard we're using, because let's say people do run for office. Voters select them based on what their past views may have been and what their sort of philosophy is and how they probably would feel about something. Whereas instead we have a precedent here that if
I think I've told you this. I hate the precedent, but
how do we get around it? Because you're basically disenfranchising voters who chose an elected official based on his or her past opinions and views. And I think it's like it's binding this body up in knots.
well, I'm just gonna say that I'm here not to pass on the propriety of the rule. I just go by what the courts have already said. I have to base it against that on a case-by-case basis. That's the best I can do.
Well, members of Congress aren't held to this standard. We don't see them being forced to recuse on anything.
You know what? I think this is the kind of thing, while I may agree with you theoretically, I got to follow what the law is. And the only way to change that is to get a law passed by the General Assembly, and that would be the way to go.
The General Assembly to allow municipalities
Yep.
more leeway in deciding,
Yep.
whether an opinion.
You give me a statute from the General Assembly, I'm good. But otherwise, I got to follow what the courts say. Is there anyone else?
I was understanding that, in general, we were to try not to recuse ourselves unless there was an absolute situation. That we were to try to, and you kind of alluded to that a few minutes ago, that our purpose was to listen to a case and make a judgment based on here and now, evidence presented, and not to bring anything to the decision.
Right.
We did, but unless there was an absolute situation, you could use your best
Yeah, I wouldn't go.
evaluative skills.
I wouldn't go that. I would evaluate it on a case-by-case basis. So let's say you were a member of the public and you were against the building of this city hall, right? And then you went and you were then appointed to the Board of Adjustment. and there was a Board of Adjustment matter that came before you about City Hall, then that's a disqualifying interest, right? So, I don't-
I agree with you there. I'm just saying, when I was first told about Board of Adjustment and how it worked, I was on another commission previously, but it seemed that the idea was you're there
You're-
to serve the city.
you're a judge.
And to make sure that you listen and are aware of the situation and make a reasonable decision. So if you can do that, you shouldn't automatically say, oh, well, I used to know this
So-
person, or I used to. know this or that.
What I would do is, and this is sort of the way I kind of go about it. I don't know that I'm going to be here long enough to really go about doing what I'm going to tell you to do. But first thing I do is I say, if there's a question that's raised in your mind about whether or not it's an appearance of impropriety, in your case, talk to Fred, right? Talk to Fred and say, this is what I got. And you can also get sort of, if it's a public integrity committee, you can get advisory opinions and things like that if you have enough time to do that, et cetera. You can do that. Are there any other questions?
All righty.
It's been an honor to have me down here. Thank you, and I hope everyone has a nice weekend.
Thank you, Max. Thank you all.